The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Mr. Leland, good morning, when you're ready.
May it please the court, counsel. My name is Daniel Gray Leland, and I represent the appellant, William Peterson III. While it may seem like this is a novel case, I submit that it is nothing more complicated than a traditional Rule of Civil Procedure 19 analysis. In fact, this court previously addressed this very matter in the case of Yashchenko v. Harrah's North Carolina Casino Company, 352 F sub 2D 653, 4th Circuit 2005. Mr. Peterson was unlawfully terminated while working as a table games dealer at Harrah's Cherokee Casino. The casino was run by Harrah's North Carolina Casino Company, which in turn is run by Caesars Entertainment, one of the largest gaming operators in the world. He brings claims under the Federal Family and Medical Leave Act and the Uniformed Services Employment and Reemployment Rights Act, USERRA, two statutes meant to protect workers and veterans like Mr. Peterson. Harrah seeks to evade liability by arguing that the Tribal Casino Gaming Enterprise, TCGE, an arm of the Eastern Band of Cherokee Indians, was Peterson's, quote, true employer and is a necessary and indispensable party. And because TCGE has sovereign immunity, the case must be dismissed. Harrah's operates the casino on tribal land under agreement with TCGE. That agreement grants Harrah's, as the operator.
Do we have that agreement? Did the district court have that agreement?
That was submitted. I do not know the exact appendix.
So that's an old one, right? You put in an old one under kind of a different operating model than they have now, potentially. And I didn't see that Harrah's provided the current contract or management agreement. Did they?
No, they did not. And that is one thing that I do want to address, the fact that it was dismissed without the opportunity for any discovery and not having that information, which I do believe is critical to this analysis.
And who do you believe the burden of proof is on to show indispensability?
Sure, the burden of proof to show indispensability when it comes to sovereign immunity is on the party claiming it.
Right.
Yeah, I was confused by the district court. Some of the reasons it gave were impairing the tribe's, contractual interests with Harrah's, but we don't have the contract, and Harrah's didn't produce it, so I didn't really know what the court was talking about.
Well, and I would suggest one thing that's interesting about that is the court should not have been making determinations about what the interest of TCGE was. They have not come forward in the case to indicate that they have any interest at all. And I submit under the Rule 19A1 analysis.
Yeah, but we let courts, even sua sponte, decide, that a third party has an interest. There might be a little conflict with saying you have to come forward with a certain document, you think?
Well, what I would suggest is, and there is a Fourth Circuit case, I believe it's the Kyver v. Murphy Brown LLC, 980 F. 2nd, 937, Fourth Circuit 2020, which was a Rule 19 analysis, and the court there noted that speculation and guess about what an interest might be is inappropriate in conducting that analysis.
So you don't lose if they just have an interest, right?
No, correct. I do want to say that there's three points that I believe mandate and compel reversal here. First, Harrah's was Mr. Peterson's employer under federal law, under claims allowing for joint and several liability, and that the district court's new definition of employer that it used in this case, applying it to TCGE, is wholly untenable on its face. Second, of course, that Rule 19 was misapplied because TCGE is not a necessary nor an indispensable party. And third, any determination of extending tribal sovereignty would require fact findings that were not done here.
Just so that I understand the framework here, as I read the district court, it found, in face of what seems like to me some conflicting evidence, that the tribe, I know y'all use acronyms, but I'll use tribe, hopefully you understand the tribe and the enterprise there, that the tribe was the employer. Was that a finding of fact that the district court made, that the tribe was the employer?
I think I would submit that that's a conclusion of law that should be under de novo review. It might, later, if there's a record, it would be a mixed question of fact and law, I believe. But on a
Well,
motion
but
to dismiss.
in this context, I mean, we can make jurisdictional fact finding, right?
Sure.
And here we've got fundamentally two pieces of evidence. We got a declaration as to how the operation works now, and that's some evidence that the tribe is the employer. And on the other side, you've got a 1996, whatever year it is, operating agreement that sort of suggests the other way, right? Suggests that maybe the private entity is the employer. I totally get, like, either of those seem plausible to me, but here it seems like the district court credits the declaration, and that might or might not be of what I would have done given the evidence that was before it, but the choice to credit the declaration over the agreement seems like one that we have to look at for clear error. And so that's where I'm like struggling a little bit. I understand the arguments that like maybe more evidence should have been submitted, maybe, but this is what the district court had. It was, called upon to make a determination. It's entitled to do that under 12b-7. Just like we make jurisdictional fact finding, we could make fact finding in this context. And then I'm sort of stuck in this world where I say, doesn't seem like a ton, but the district court made a finding, and we ought to review that for clear error. Help me understand why that doesn't, like, sort of resolve the case?
Sure. And that's a good question. Thank you, Your Honor. What I would submit first is that you obviously can read the district court order, and it's certainly light on facts. And I think it makes a huge stretch there. I understand that.
Yeah, okay, but it says this, right? It says that, the declaration is evidence of the agreement, and even viewing that evidence in the light most favorable to the plaintiff, it shows that the tribe was the employer, right? And that's what it says.
I don't believe
Understand.
that's what the agreement says. I mean,
No, that's what the order says. That's what I was literally reading from the district court's order when
Sure.
I just said that, right? I'm just repeating what the district court said, and it's crediting one piece of information. You gave a different piece of information that it does not credit. All right, what do I do with that?
Well, what we know is that, and this is from the appellee's own findings, is that Harris has exclusive authority over everything related to employees, over hiring, over firing, over supervision, over policies.
And the evidence of that is this 1996 agreement.
And in addition to that, appellee effectively admitting to that at oral argument. What appellee says at oral argument.
Effectively, I'm sorry, say that one more
Sure.
time?
Well, what the appellee said at oral argument.
But is that evidence? Like, what I'm trying to understand is, like, what's the evidence that we're looking at? Everybody wants to say, my opponent effectively admitted that they lose, right? Rarely did they actually do that. But what is the evidence, other than the agreement on the one hand and the declaration on the other? There's lots of other talk about things, but it seems like it's just these two pieces of evidence, and the district court has to, like, decide, because they're in conflict.
I don't see how they're in conflict as an initial matter.
Okay, so that's an argument. The district court doesn't seem to take that tack, but that's an argument. Is there anything else, like, help me understand, so I understand that argument. They're not, your view that maybe they're not in conflict. What else am I looking at to sort of understand why there's clear error to choose the declaration over the agreement?
Again, and what I would suggest that it should be under de novo review. And I think what has happened with courts lately, this circuit
De
examine
novo
this issue.
review in deciding to credit one set of evidence over another set of evidence?
I don't know when you keep saying that the district court was crediting evidence that said what? I mean,
Defendants have provided evidence of a management agreement, and that evidence clarifies that evidence being the declaration, that evidence clarifies, and it makes 3 factual findings that inextricably lead to the conclusion that the tribe is the employer, right? It uses the acronym, so it's hard to follow, but ECBI has delegated its obligations and rights under the management agreement to the tribe, right? Peterson was employed as a table games dealer by the tribe at Harrah's. All tribe employees, including Peterson, are employees of a tribal enterprise. Right? Those are like factual findings that it's making.
and the court's basis for those factual findings were based on 2 things. One, that that the TCGE wrote the checks, and that TCGE administered drug tests before people were hired, as they're required to under the Gaming Rights Act. That's what the conclusion was based on. I'd submit that those 2 things do not make the tribe to be an employer. If you look at the definitions under the FMLA of employer.
And so your response to me is that the declaration, you've picked 2 things the declaration says. It's not everything the declaration says, but that's fine. But that the declaration isn't sufficient if it was standing alone to establish that the tribe was the employer.
I would say yes, and I would say that all the declaration says is that the tribe did the payroll checks. They don't say they had any control at all whatsoever over any employment decision. It's based on the fact that they wrote the checks and they did drug tests. I submit that can't be the definition of employer. If you look at the statutory definitions under the FMLA, under USERRA, they're broad definitions, but the TCGE, I'd submit, doesn't meet those definitions of an employer.
Do you concede that if the tribe is the employer, the tribe is an indispensable party?
No.
Tell us why, if the tribe is the employer, it's not an indispensable party here.
Certainly. And what I would direct the court's attention to is a Fourth Circuit case from 2019, Williams v. Big Picture Loans, 929 F. 3rd 170. And what the court did there was, just because someone says, I'm an employer, that doesn't necessarily confer tribal sovereignty. In Williams v. Big Picture
Well,
Loans.
I guess I'm not asking about, the tribe has sovereignty, and the district court said the tribe is the employer. But there's also this agreement where the tribe delegated to Harrah's responsibility for managing the employees. And the district court in the hearings seemed to be discussing a very plausible concept where the plaintiff could sue both of them or either of them, and the tribe and Harrah's hash it out in their management agreement or some other indemnification agreement about who ends up on the hook for that. But that's not really the plaintiff's problem. That the plaintiff could sue, your argument, as I understood it, was the plaintiff could sue Harrah's because it's also an employer under the statutory definitions, even if the tribe is the true, right, who pays the paycheck, who actually hires and fires.
Well, the tribe doesn't make the decisions to hire and fire. They don't make those decisions at all. How we get to a true employer
But
simply because of the payment of a check.
Could the district court order reinstatement without the tribe as a party? It doesn't seem likely, right? The tribe could say, we are the employer, we're not going to employ this person. But that, again, doesn't make them an indispensable party. There are ways around that. And I'm trying to disaggregate whether you think the factual finding that the tribe is the employer sinks you on necessary and indispensable party, or whether those 2 are separate.
Part of the Rule 19 analysis is to say that they're separate. And even if the court would find that TCGE was an employer as well, I suggest that they're not. They don't meet the definitions of an employer. But even in that case, because these claims, FMLA and USERRA claims, allow for joint and several liability, the tribe is not a necessary and indispensable party. The very first part of a Rule 19A analysis is whether or not the court can afford complete relief in the absence of the current then non-party. And under joint and several liability, the court could. TCGE does not need to be involved at all in the decision about these FMLA or USERRA violations. What I'd submit to the court is in Yushenko, if we look at what the court did in Yushenko, the court knew when to say there was necessary and compulsory joinder. It did that in the tribal preference hiring policy. When this court addressed the FMLA claims, it didn't look at all to whether or not that was an
Are you challenging any
employer.
policies? Is this just one plaintiff? It's not a proposed class action or anything?
Yes, it is a single plaintiff under FMLA and USERRA.
What was the district court talking about when it said TCGE would be able to continue enforcing the policies to which Peterson takes issue? What policies do you take issue with?
I don't know exactly what the court said there. I assume it's saying something about enforcing not following FMLA or USERRA. That's as best as I can make sense of it.
The prior cases in the Western District, they were about policies, but not your case. Other cases in this similar fact pattern that have come out of the Western District have been challenging policies, but this, I didn't see anything in your complaint challenging any policy of Harrah's or the tribe.
No, that would be correct. And in making the.
You see, any counsel, Judge Richardson was, like your colleague was asking you questions about this declaration. A lot of this declaration, we don't have to give that kind of credence to that, nor should the district court. They're making conclusions. It says basically, I'm telling you that the employer is the tribe. That's a legal conclusion. That's what we're here for. I mean, that means you could have any declaration, well, I'm telling you right now, I don't care what they do at the casino. The tribe is the employer, and put it in writing and sign it. Then we say, oh, well, the judge used that. I mean, no factual question here in terms of that. You know, why didn't you put in a declaration? Why didn't you put a declaration? I'm just asking. I'm interested. So, to me, I practice law. If everybody's going to start playing music, I may as well join the band too. Is my question quizzical to you? They put in this declaration. You could do the same thing. You could have people, other employees say, yeah. My manager, this person, my foreperson is this. He's the one, or she tells me what to do, and those kind of things like that. Declaration. So then, so the question now, we're supposed to now bend to this one. That's basically the conclusions. Go ahead. I'm just wondering. But
Sure. Well, what I would submit is, in what you said when you started that comment, was that this is a legal conclusion. And I believe that's the case. If it was as simple as us providing an affidavit saying what we already know, the fact that Harrah's has complete and exclusive control over everything that he did, over his firing and termination, we could contest that, but that seemed inappropriate to supplement the record at that time.
But just to be clear, you did not submit a declaration to that effect, right? So you didn't submit a declaration of a person with knowledge as to how the system operated. Right, so your client did not submit a declaration that said, my checks came from Harrah's, or that my directions came from an individual I knew to be an Harrah's employee, or that I got directions from corporate Harrah's, or whatever it is, that, I was led to believe that I was an employee of Harrah's. None of those things were in a declaration that you submitted.
Correct, Your Honor, and I just encourage you to remember the procedural posture of the case. It was on a motion to dismiss, a motion based solely upon the complaint.
But Rule 19 permits fact-finding, right? And you sort of acknowledged by submitting the operating agreement from 1996, and as I think Judge Gregory is suggesting here, they submitted a declaration. You could submit a declaration. That's sort of what we do at the jurisdictional, initial proceeding posture, is we take somebody with knowledge and they give us the information the best they can. And so you weren't prohibited from doing that, right?
I missed the question.
You weren't prohibited from submitting a declaration from a person with knowledge as to like how the system operated.
I submit that I believe, I mean, the reason why we didn't is that it would be inappropriate to do that on a motion to dismiss. I understand certain things can be added on a Rule 19 motion.
Your
as a
view is
general-
it's inappropriate to submit a declaration from a person with knowledge in a 12B7 setting.
On a motion to dismiss, based upon a complaint, yes.
Did you object to this declaration?
No, Your Honor.
Wait. But I guess the question is that because the tribe is an employer, it doesn't mean that there can't be another employer. There are cases where you can have more than one employer, correct?
Correct, and of course, that is what this court said in Yasheko.
Exactly. All right, thank you, Mr. Leland.
Thank you.
Mr. Clays?
May it please the court, counsel, thank you, your honors, for your time and attention today. Are individuals who are employed in the casino gaming enterprise in casinos located on tribal land employees of the tribe such that their employment claims must be brought against the tribe? And does the tribe's tribal sovereign immunity, which forecloses their participation in the litigation, require dismissal? Every single case in which a court has been asked that question, the answer has unanimously been yes. Mr. Peterson requests this court to find abuse of discretion because the district court in our case reached the same conclusion.
So you're saying that, on your position then, if there was just blatant sexual harassment, I mean blatant such, then that would be total immunity. I mean, so if an employee is physically and sexually assaulted in employment, course of employment, there would be complete immunity? None of the protection of Title VII, none of those things. Here's FMLA and those are federal labor standards. But is that your position?
It's our position that Mr. Peterson has the right to pursue his claims against the tribe.
No, that's not what I asked you. It's a hypothetical. I know it's not this case. I want you to answer my hypothetical. You're saying that if a person is brutally sexually assaulted in the course of employment, that there's complete immunity.
No, Your Honor, to the extent that the employer is not a tribal sovereign nation that is immune from suit under Title VII. In fact, the Dawa Vendera decision...
No, what? What's the no to? I thought it sounded like yes you're going to.
No, and the employer is not immune from suit under Title VII if the employer is, in fact, that plaintiff's employer. We don't
That's what I'm saying. You're saying that they're not the employer on any situations. That's your position, isn't it?
It's
and
our...
Because you said step one, they're the employer, and two, they have sovereign immunity. In that framework, my hypothetical, why wouldn't they be immune? Even if it's a blatant sexual harassment in the workplace.
If the hypothetical relates to the tribe as the employer,
No, it relates to the person that's in the, I've got to put it in the context of hypothetically the casino, because that's what we're talking about in the case situation.
so it's our position that an individual who is employed by an employer who is not a tribe and therefore does not
So
have...
you're not going to answer my hypothetical.
I'm trying, Your Honor.
No, you're not
I
trying
think
very
he's
well.
asking, where would they sue the tribe?
They have the right to sue the tribe in tribal court under tribal law. And nothing that occurs...
And nowhere else, right? That's your point here. It's like, that's what a tribe is, right? They're like, yes, if you bring a sexual harassment case against the tribe, it is immune in federal court.
That's our position, and that position has been recognized by the United States Supreme Court. And
That's not that's sort of not controversial, that if you sue a tribe, it has immunity in federal court. And that's true whatever the statute is, whether it's FMLA or Title VII or whatever statute we're talking about. If you sue a tribe in federal court, it has immunity.
That is our position, unless it's abrogated by an act of Congress or the tribe, it waives that immunity. Mr. Peterson argues.
But they can go to tribal court and seek relief in tribal court.
Yes, Your Honor, that's true, and there's no preclusive effect that this litigation has on Mr. Peterson's ability to pursue his
Well,
claims.
then why
whatever-
did you say they have sovereign immunity then here?
The tribe is a sovereign nation and can only be sued within its own sovereign jurisdictional setup, tribal courts. And so Mr. Peterson has the opportunity, and in fact may already be pursuing his claims against the tribe in tribal court. And nothing that occurs here, whether it's in Mr. Peterson's favor or not, precludes him from pursuing whatever relief might exist under tribal law against the tribe arising out of the exact same operative
But
facts.
he hasn't sued the tribe here, right? So we're talking about Harrah's, and who has the burden to prove that the tribe is necessary and indispensable?
That's correct, Your Honor, and we believe,
You agree Harrah's has that burden?
yes,
So
we,
the burden to introduce evidence and prove all of the requirements, that's all on Harrah's? It's
Yes.
not the plaintiff's burden at all?
yes, Your Honor, we agree that under Rule 12b-7, the court can consider, and the district court properly did consider, evidence outside of the four corners of the complaint, and its findings were mixed findings of fact and law. It determined that the tribe was the employer, but in making that determination, it relied on the limited factual record that was presented to it.
So what did the court rely on when it said that any judgment would impair the tribe's contractual interests with Harrah's? That it would be prejudiced in its absence because it would interfere with its ability to resolve its contractual obligations with the tribe? What evidence did the court rely on to make those conclusions?
I would submit that the declaration of Ms. Bridges addresses that the management agreement currently in place, or in place at the time
Well,
of...
it does. Does it have the contractual, did she attach the contract to her declaration?
No,
Or
Your Honor.
mention any contract provisions that would be impaired?
Under paragraph 7 of her declaration, she says that the management agreement expressly provides that these individuals are tribe
They're
employees.
employees,
And
right.
not Harrah's employees. She did
So
not
how-
attach...
So your position is that's the only contract interest the court is talking about? Just the provision of the contract that says these are tribal employees?
Yes, Your Honor, that may have been all that the district court considered, but that was sufficient for this court in the Yashenko decision on the Section 1981 claim. That was sufficient for the Dawa Vandera
Well, no,
decision.
it wasn't. I mean, that in Yashenko and in the two magistrate cases from the Western District, these were all cases challenging a policy that was in the written management agreement or class actions challenging the FMLA policy that was being, right? So that's what the court in those cases was talking about, the policy. The court had the management agreement in front of it and was saying this contractual provision and this contractual provision will be impaired. This is how the tribe is indispensable to this litigation. Its rights are being determined by this litigation. But here we don't have the management agreement. There's no policies being challenged. And as you know, in Yashenko, the FMLA claims went forward. So help me understand why those cases, why all of that applies here. This seems to me like a very different context with a very different factual record.
We would agree with you that Yashenko is different. The facts actually bear that out. In the Yashenko decision, the reason why the court wasn't considering Rule 12b-7 dismissal or Rule 19 joinder analysis is because it was never raised by Harrah's. And the facts actually establish why. In that case, the factual record showed that Mr. Yashenko was hired in 1994, before even the 1996 version of the agreement
That
was
was
in
the
place.
leasing of employees and
The-
stuff, not the,
Correct, Your Honor, the leasing of employees. But the record established that that he was hired by Harrah's, was employed by Harrah's. And in fact, the reason why his position was eliminated, as the court in Yashenko recognized, was that beginning in 2003, these positions in the casino were being transitioned from Harrah's jobs to tribal jobs.
So is it your position that just by proving that the tribe is the employer, you have proven that the tribe is a necessary and indispensable party? You didn't need to show anything else?
No, Your Honor. Under Rule 19b, there are multiple factors that the court could consider. It's an illustrative list. The court need not consider all of them. But I would note that those factors need not be weighed heavily when the basis for infeasibility of joinder is based on immunity. That's what Clark and Humble both provided, relying on the Cascali Ninth Circuit Court of Appeals decision and the Enterprise Management Consultants 10th Circuit Court of Appeals
Yeah, I mean,
decision.
Clark and Humble, though, with those were different factual circumstances, class actions, challenging policies. So you might need to apply that to this particular case.
And we believe that the district court did so. The Cascali decision provides that when immunity
Because
is
the
the
district court's opinion to me read like kind of a, no disrespect at all to this district court. I love this district court. But a little bit like a cut and paste from Clark and the other magistrate judge decision. And when he's talking about contractual provisions and policies, that applied in those cases, but it doesn't apply here.
There is no tribal hiring preference policy at issue here, which was the issue in Yashchenko and the issue in Dawa Vendera, but we would submit that it is not substantially different and no clear error
So
occurs.
what is the policy? So Judge Rushing asked your colleague, when the district court says, you know, the tribe would be able to continue enforcing the policies to which plaintiff takes issue. What do you, does that have meaning? Like, what does that refer to? Obviously, if it was a hiring preference, that is an obvious answer. But when it says the policies to which plaintiff takes issue, what do you understand that to mean?
Our understanding of that was that Mr. Peterson in this case is challenging the decisions that were made by individuals within the casino who, based on the declaration from Ms. Bridges, were themselves tribe employees.
Wait, but why would that be? Help me understand that, because that doesn't seem to match up, right? That seems to agree with your colleague over here. There were no policies, right? These are just like individual one-off decisions. Is that, help me understand, like that, your answer to me is like the policy is the as-applied decisions. Well, that suggests that's not a policy decision, that's just like a one-off decision.
We would suggest that the court did not abuse its discretion from extrapolating from Clark and from Humble that what was challenged here was individual conduct. And
So
that
there are no policies. You can't identify any that are being challenged here.
to the extent that there is a policy at issue, it's the provision within the management agreement that states that these individuals are tribe employees and not Harrah's employees. And so it's possible that the court was contemplating that provision when it provided that language in its order.
Why didn't you attach the contract? You know it's your burden.
We do know it was our burden in Clark and in
Right.
Humble,
No,
actually.
you're talking about another case. I'm talking about this case here. You're always deflecting. I'm talking about this case. You have this declaration here. Why didn't you attach the contract? Because the burden is on you and all inferences are drawn in favor of the non-moving party. Why didn't you?
It was a choice that.
Nothing in there that would help you? Was that reason?
I'm sorry, I missed
Was
the
there
question.
nothing in there that would help you? That's why? Why?
No, it's not that we don't believe that it would help us, it's that we believe that Ms. Bridges' declaration and her sworn testimony was sufficient. In fact, that was the same that was relied on in the Clark and Humble decisions, was sworn testimony from an individual in an HR capacity regarding the
Well, I think
contents.
Judge Rushing has laid that out as best that I could ever come close to doing so, how that's totally inopposite in this case, and all those things. But anyway, I just wanted to ask the question, I want to be fair, ask the question to the other side, I'm asking you. Go ahead.
And it is a fair question, and we would submit that those findings of fact are reviewed on an abuse of discretion standard. And the court correctly noted that on the other side of the record, there was nothing more than what we would consider to be inadmissible hearsay evidence of
Can
what.
I ask you one more question about another statement of the district court that confused me?
Absolutely.
The district court said that Harrah's would be prejudiced by the tribe's absence because a judgment in the absence of the tribe would interfere with Harrah's ability to resolve its contractual obligations with the gaming enterprise. What does that mean? What are Harrah's contractual obligations with the gaming enterprise that would be interfered with? Ability to resolve its contractual obligations.
We would submit that the contractual obligation at issue is the provision that provides that these are tribe employees and not Harrah's employees.
So how would a judgment, an FMLA judgment in the tribe's absence interfere with that?
Necessary in a determination of liability here is that Harrah's and Caesars were the employers and not the tribe. And so that interferes with the provision of the agreement that says the opposite is true. That is our understanding
So
of
you
that.
disagree with the idea that under the FMLA, a plaintiff can sue someone acting on behalf of the employer?
We do not disagree with that position. However, the case law and the statutory provisions that Mr. Peterson cites in his appellate briefing establish only that under the FMLA, an individual, a person, could be considered a joint employer in certain circumstances under the FMLA.
I mean, it seems to me the tribe may not be impaired at all. I mean, if there's a judgment against Harrah's for, the way that they've handled the employment relationship, or even telling Harrah's you have to pay money, or you have to rehire this person, the tribe can, Harrah's comes to the tribe and the tribe can say, too bad. Like, we don't have to hire anyone. This is not a judgment against us. It's a judgment against you, Harrah's. Now, you guys may have an agreement that works all this out, but we don't have that and we don't know about it. So how does it impair the contractual obligations?
Can you ask that question again? Sorry.
I see how Harrah's might be left holding a bag here and might be inconvenienced, but how does it impair the tribe's ability to protect its own contractual interests?
In this case, the tribe's contractual interest is in preserving the provision of that agreement that states that these are tribe and not Harrah's employees. Similarly,
How does it interfere with that? How would this case interfere with the provision of the contract saying these are tribe employees?
because
They
a
can
lot,
still have that contractual provision, they can still enforce it. It doesn't say, it doesn't take away any of their employees. Just practically, this Rule 19 is a very practical question. So practically, how does it impair the tribe's ability?
from a practical standpoint, because the tribe paid Mr. Peterson's wages, any sort of adverse judgment in Mr. Peterson's favor
But
regarding.
it's not just money, right? I mean, the answer is the court, what they've asked for is reinstatement, right? So they've asked the district court to order Harrah's to rehire him as a table dealer. And if Harrah's is not permitted to do that under the operating agreement, right? Then that is like puts them in conflict with the tribe.
Could that be avoided by how the court shapes the relief?
We don't believe so. Mr. Peterson is the master of his complaint, and the relief he seeks here is wage-related damages, which, if awarded, would have to be paid by the tribe, who is absent from this litigation, and reinstatement.
No, it would be a judgment against Harrah's. The district court wouldn't be telling the tribe to pay any money. It would be telling Harrah's to pay the money.
And under Rule 19, the court needs to determine, and it did in this case, whether or not the relief would be effective in the absence of the tribe. Because the record before the district court showed that the tribe at all times was the payor of Mr. Peterson's paychecks.
Well,
The
that
district court
might
is
be like too bad for Harrah's. It has a judgment against it telling it to pay this gentleman, but surely there's an agreement with the tribe about how that sort of thing will be sorted out when the tribe has given Harrah's responsibility for all employment matters.
That may be possible. The record does not include the current version of the agreement and what indemnification provisions may or may not apply here. But I would submit that the purpose of Rule 19 is to avoid an outcome like that, where both the district court and Harrah's would
But
be
that's
stuck.
kind of like joint and several liability, right? That's never a reason to make a party indispensable. The fact that, well, there's someone else who actually owes this money to, or someone who's indemnified the defendant. That kind of is the defendant's problem.
And Mr. Peterson raises this joint employer theory for the first time on appeal. He never raised it before the district court, and so it was not afforded the opportunity to consider those arguments. I would submit that it's not properly before this court either. Nonetheless, even if we want to address it, Mr. Peterson relies on FLSA case law that provides that in certain contexts, an individual can be considered a joint employer. He relies on FMLA case law that provides only that in certain contexts, an individual can be considered a joint employer. And he relies on USERRA statutory language that provides that, in theory, joint employment is possible. But he does not counteract or cite a case that reaches the opposite conclusion of the Manzano decision, which found that in that case, the tribe at issue there was not a joint employer of the plaintiff. And even if this court were satisfied with an argument that was not raised before the district court, and therefore there's no abuse of discretion that the district court did not consider it, even if it were satisfied with this joint employer argument here, the Gillian versus Koch trucking decision in the District Court of Maryland provides that even in those circumstances where an absent party who cannot be joined because of immunity, in that case the school board, was no more than a joint employer along with the named defendants in that case, Rule 19 still rendered them an indispensable party and required dismissal of that case. Importantly, taking into consideration that the plaintiff in that case had adequate relief even if dismissal occurred. In that case, the plaintiff had the ability to pursue his claims against all of the joint employers, including the school board, in state court, where the school board was not immune. Same here, where Mr. Peterson is not precluded, regardless of the outcome of this case,
So your argument is that because the tribe is the true employer, therefore the tribe is indispensable.
Because the tribe is the true employer, it is necessary. Because of the analysis of the factors.
You haven't put forward a case that is necessary. You don't have any contract here.
And I'll just,
It's unbelievable that you said that you can do that without even putting it in a contract. You don't even have the facts to that in the record to support that. You said you have this really bare bones declaration that just basically says that, well, we're the employer. But how does that, in terms of they're indispensable in that sense?
I'd like to answer your question. I'd note that I am over
go
time.
ahead.
Okay. So you are correct that under Rule 19A, they must first determine necessity. And under those circumstances, the court considered that the tribe had an interest relating to the subject matter of the litigation, such that their absence impaired or impeded their ability to protect that interest. It followed the rubric that was laid out by Clark and by Humble in finding that it has an interest as Mr. Peterson's employer in defending against his workplace claims.
That's because they put forth a case that said that it would be inconsistent with the tribe's policy and interrupted. You don't have that case here. There, in terms of choosing, in terms of hiring preferences there, they say we could not fulfill that what the tribe will require. You don't have anything in this record here that is something about what happened in terms of the employment environment that interferes with the tribe at all. That's what Judge Rushman was going through, and the burden is on you.
Yes, Your Honor, we agree that the burden is on
I think
us.
it's so glaring and unbelievable that you didn't put the contract in. That would happen if something is indispensable. That's the sine qua non. This is why. These are the things we couldn't do under this contract if they're not here. These are the things. And you want to come here and say, well, I don't need to put you anything. We just said that with this declaration, and we're supposed as a court, in a case like this, these are very important. The FMLA is very important. It's made a big difference in terms of employment, in terms of people being able to take care of families and take care of their health issues and work. They're not small issues at all. It can't be whisked away in terms of your burden. I mean, I'm about to say something, but never mind. You're smiling, but I'm just wondering why you didn't put the contract in, and you say that's so important to your case.
We believe that Ms. Bridges' testimony, based on her knowledge of the contract and the employment arrangement, is sufficient. She testifies that they were hired and fired by the tribe. The background check
That's
was
hearsay. I mean, in terms of hearsay, the document, you put the documents in. I mean, that's one-on-one, right?
We would note that Mr. Peterson never raised that objection below. The court couldn't consider it.
And we raised the objection. We're looking at it in terms of what it is, in terms of your evidence.
Yes, Your Honor, and we would also argue that we provided the district
Your
court.
time is up, but go ahead. Finish your last thought.
I'm sorry. We also provided the court, and the court below considered the gaming compact, which itself is a contract between this tribe and the state that requires that these individuals be hired, fired, be managed and supervised and have their licenses maintained by the tribe and not by anyone else. And so to the extent the court feels that contractual language is necessary for us to satisfy our burden, we provided that with the district court for its consideration.
Licensing is not an issue in this case, but go ahead, no, that's fine. Thank you so much, Mr. Leland.
Thank you, Your Honors, for your attention.
Do you have anything further? Yeah, you have time reserved. Do you have anything further? Sure, it was a question.
I know I have very limited time here. The one thing that I just want to comment on really quickly is, it seems to be that we're operating on an assumption that even if someone just sues a tribe, they have immunity in federal court. That's simply not true. I'd encourage this court to review its recent decision in Williams v. Big Picture Loans. I've mentioned it before, 929 F3rd 170, 4th Circuit 2019. In that case, it was looking to see if something was an arm of the tribe, and it went through the 5 breakthrough factors.
You haven't disputed that here, have you? That the gaming enterprise is an arm of the tribe? Like, we're just not there yet in this litigation, are we?
I'm sorry.
Are you asking us to conclude the gaming enterprise is not an arm of the tribe?
No.
Okay,
What I'm suggesting is that Harris certainly isn't.
right.
Yes, and, you know.
Has anybody argued that Harris is an arm of the tribe? I don't understand that.
Sure. It's saying that Harris should not, they're trying to attach sovereign immunity to Harris, saying that it's a subordinate economic interest and arm of the tribe.
Did someone argue that Harris is an arm of the tribe?
Well, how else does sovereign immunity apply?
They're trying to say that the tribe's an indispensable party, and therefore you don't get to proceed. That was
Certainly.
the whole premise here.
Yes,
But not because they're not an arm of the, I mean, I guess I don't follow that at all.
sure.
I wouldn't fight sovereign immunity if I were you. Yes.
I understand that. I am commenting, however, that the court has looked at whether or not sovereign immunity applies to certain entities that are of tribe. And I think ipso facto, it should apply with more force here if the courts have looked into.
Do you agree the gaming enterprise has sovereign immunity? If you sued the gaming enterprise, could you do that in federal court?
No,
Right, because it has sovereign immunity.
certainly.
Okay.
The only other thing I think is slightly confusing is that, the policy that seems to be suggested that might be infringed is a simple statement, well, there are employees, and I think that's a little bit circular. I want to refer the court to.
Why isn't the policy that like we can fire employees at will? Right, so the policy is that like we can fire people, right? We, the enterprise, can fire people, and there may be, limits for other people firing people for bad reasons, but we as a enterprise can fire people for whatever reason we like, subject only to tribal courts, right? Why isn't that like the policy? I mean, we might not like that policy, but that sort of seems like the policy that the enterprise has suggested.
I see that my time is coming up, but what I would
I'm
suggest is.
sure Judge Gregory will be happy to let you answer the question.
Absolutely, and you realize this is a counterfactual question. Judge Richardson asked you a hypothetical, in a sense, because they haven't put forth that policy. But go ahead, answer the hypothetical.
Well, I didn't quite understand that.
Well,
It
you
was
were saying that the
hypothetical.
policy
We don't
was
have
we'll
a
be able
policy.
to, because we're the tribe, and
Sure.
if we're the sole employee, we could just fire you, just say, the sky's blue, you're gone. And therefore, if we have to be under the auspices of fairness and justice and all the federal arrangements to protect employees, that would hurt us from being able to just say, you're gone. That's really the question. And why is that not a policy to be protected by here? And therefore, you shouldn't be able to sue them because they're indispensable.
Sure. And I would say, it seems like there's some disagreement about the application, but I believe that Big Picture Loans does specifically address that. And I
I'm
was going
familiar
to
with those
say.
cases, yeah, the gaming, the loan cases. The loan, yeah.
Yeah, the
I've had a
payday-
lot,
the
I've had a lot of
payday-
those cases, yeah, go ahead.
Payday loan cases where, it
But that's
depended
not
on the
what Judge
facts.
Richardson is asking you. I tried to go ahead, answer the
Sure,
question.
well,
You can go back to my question or Judge Gregory's question. They're different questions, but you can answer either one of them.
But no, please answer Judge Richardson.
sure. What I will say is, I just would refer to observation by the Second Circuit Court of Appeals that it made in one of the payday loan cases, which is a tribe has no legitimate interest in selling an opportunity to evade state law. And to answer that, to answer the question is, I think that, I believe, does address it. When it's looking at the interests of the tribe, to say that the tribe's interest is selling the ability to evade state law is a different, a different thing here, as applied to Harris. Seeing that my time is up, in conclusion, we recommend that the district court be reversed and this be remanded for future proceedings. Thank you.
Thank you, Mr. Leland. Thank you, Mr. Clays, for your argument. We'll come down to Greek Council and proceed to our last case of the term. Ms. Casvant, when you're ready. Oh, I'm sorry, you may be seated. I'm sorry.
May it please the court, I'm Dana Kersvong for Deputy United States Marshals Ryan Godick and Tristan Martin. As 4 circuits have now held, cases involving the Marshal Service's execution of arrest warrants arise in a new context under Egbert, and there are special factors that counsel hesitation. This is a new category of defendant operating under a different legal mandate with a different mission. The federal-state cooperation is key to that mission. As the 11th Circuit recognized in Robinson, this is a distinct statutory scheme under which the state and federal officers operate, where they need to cooperate. And as the 10th Circuit said,
Excuse me, in terms of the 4th Circuit, are we limited to, because they're not the same officers that were in Bivens, because the U.S. Marshals, that's the reason? For one of them, first context. Is that solely the reason?
so
Have we extended to other federal law enforcement officers?
this court has extended to other federal law enforcement officers, in Hicks, for example, but here, there's really a material difference, right? That Abbasi says the new context inquiry is easily satisfied, and where we're talking about this federal state cooperation, which was not considered in Bivens, as the 10th Circuit, for example, acknowledged, and it's really central to the mission of the Marshal Service to apprehend, execute warrants on the most dangerous fugitives
Almost in
the
every
United
case, a law enforcement officer is essential to their work to enforce the law and do so in executing warrants and arrests and park officers. What about correctional officers in prison?
Well, Your Honor,
The 4th Circuit cases in that, recent cases?
well, there's certainly fields, Your Honor. We take each of these cases after Egbert on their own facts, and the context matters.
But I was just
And-
reading with the first one, the mere fact is the U.S. Marshals, certainly, I'll for sure, if a correctional officer is included, then I don't think there's much delta between the U.S. Marshal, and other federal officers in terms of new context. We found that was not a new context solely because it was a correctional officer, right?
Your Honor, in Fields, the new context argument had been waived, but there, the court noted in a footnote that if it was similar to something, it was similar to Carlson. here, what we're talking about, so the court in that case didn't decide whether it's a new context, as that argument had been waived. But here, we're talking about this cooperation between the different agencies. We're also talking about execution of a warrant, which
How's
this
that
court-
relevant, though, that fact that they were doing in conjunction? Why does that make it a new context? It's the same field officers doing the same type work. Do you think that makes it a difference? Because there were local officers with them?
Yes, Your Honor, so legal liability really matters in putting together these partnerships. The Capital Area Task Force has partnerships with over 100 different agencies, just that. And when we're talking about putting together these partnerships, what we know is that the state and local officers, if they are subject to liability under Bivens, the federal government doesn't provide the same indemnification as of right as that a lot of state and local departments do. So it's a different situation, and as the Sixth Circuit said, the 10th Circuit said, the 11th Circuit said, it will chill recruitment to have this liability. And, of course, as the Supreme Court said, if there is any reason, even one, to think that this is a situation where Congress might be better suited to decide if there's a damages remedy, then the court can't create a damages
Can
remedy.
I ask where you draw this line? So Bivens sort of involved an agency that doesn't exist anymore, but do you agree that if it was the FBI and they were enforcing, say, various federal statutory violations, that the fact that it was the FBI and not a drug agent, that would not create a new factual scenario, that distinction alone?
Well, Your Honor, after we look at each of these cases on its
I
own
know, and I'm
facts.
asking you this particular fact, right? So I got, instead of Bivens, everything else in Bivens is the exact same, except the agency is the FBI, and the statute being investigated is 922G instead of whatever they were investigating in Bivens, right? So it's a different statute and a different agency, but they are similarly doing everything else the same. Do you think in that hypothetical, it's obviously hypothetical, that necessarily creates a new context?
Well, the Ninth Circuit said that the FBI was a new context. The Seventh Circuit said that it was not. I can't answer that question here. What I do know
Okay,
is that.
all right, fine. Except hypothetically that would be the same Bivens context. Help me understand why the U.S. Marshals, when they're assisting with the arrest of state fugitives, that is not sort of analogous there. So if you assume for a minute, hypothetically, that an FBI agent enforcing a gun law is not a different context from a drug agent enforcing a drug law, why is the U.S. Marshals' work meaningfully different?
Yes, Your Honor. It's meaningfully different because, as the 11th Circuit said, the Marshal Service operates under this distinct statutory scheme where state and federal officers have to cooperate to apprehend these fugitives, the most dangerous fugitives in the United States.
It's more like immigration type work because you've got sort of like different, interest at stake, federalism interests at stake.
Yes, there are different federalism interests at stake when you talk about these cooperation agreements. And, of course, the legal liability matters in putting together these kinds of cooperation agreements, which is a reason to think that Congress would be better positioned. There's also the presence of a warrant, a state warrant. This court said in Hicks and Anna Peretti that execution of a warrant created a different context. And there are
The warrant
special
didn't matter in
factors.
this case, though, does it? They had a warrant, but the warrant is really not the focus here, right? They were in the house, it wasn't based on the warrant. They were in the house at the permission of the homeowner. Am I wrong?
Well, they were in the house to execute the warrant.
No,
which,
they were in the house because the person let them in. When, for example, when the question was to the door, the person who answered the door, is this person here for whom we have a warrant for arrest? The answer was no. Am I right? The answer was no.
You are right that she
Okay,
said that,
she
yes.
said no, and they were not in. Then they said, well, can we come in and look for him? And they said, yes. And they told them, you need to get outside of your home, and they left. That was all at the benefit or the graciousness of the homeowner. That wasn't a warrant. They were there, they were in the house because they were given permission to be in there. You do agree that an arrest warrant doesn't give you the right just to go in someone's home. Anybody's home, say, I don't care, right? You think an arrest warrant would allow you to just search someone's home? If they had said, no, you can't come in my house. I'm asking you, you're a lawyer, can they? Would that allow you an arrest warrant, do that?
Your Honor, what I know about arrest warrants is that they do give some authority to go into a home and look for the suspect.
Under what circumstance? They gotta have a reason to believe that he's in there.
Right, which they
And
did in this,
a denial by the person at the front door isn't necessarily defeat the ability to use an arrest warrant to look in somebody's house.
Right, because, for example, you hear noises, you hear disturbances, there are other physical examples. You saw them peeping through the window, they just arrived an hour before. That's some factual circumstance. But you just can't say, I'm coming to your house. The point that they allowed them to come in. That's undisputed.
they did allow the officers
I
to come
said,
in the.
that's what I said, they allowed, the warrant was not, the warrant does not permit it, she permitted it.
So,
Were they invited into the downstairs? Were they given consent to go into the downstairs?
I don't believe I don't believe the record shows that they asked separately about the downstairs. I'm
Right,
not
and
sure
it was separated off by a door that wouldn't open,
that's right, Your
right?
Honor.
And so they broke the door down and sent a dog in?
That's
Did they
right.
receive consent to do that?
They did not ask separately to do that, as far as I'm aware. The other reason the
Did
warrant
they have
matters.
reason at that point to believe that the fugitive was downstairs?
They had reason to believe he was in the house. I think the record shows that they knew his truck was outside, they had been looked at the residence. But the other key about the warrant
But they also
is
knew
that
there was a pregnant woman in there. I'm not pregnant, but a woman with a 4-month-old baby in there.
there have been no fact findings on that,
Oh,
just to be
yes,
clear.
no. The facts at this point are disputed. That's what the district court said. The sister said,
Exactly.
I told them that she was there and the baby. Right?
Yes.
So that we're supposed to now ignore that at this point? Don't we have to assume that's
Your Honor,
correct, the facts?
You do assume those facts.
So that you have to then at this stand, that they did that, they put that dog in there knowing, that having told a 4-month-old baby and mother were there in that room. And they put a dog in there and the dog bites to kill. Am I
Your-
right?
I don't know that the dog bites to kill,
Well,
but the,
what kind of dog was it? You don't even know?
ooh, I'm sorry, Your Honor, I don't know.
But
I
you knew
know
the
it
dog
a
was trained to
canine.
bite whomever they came in contact with, right? And here they bit flesh, a hunk of flesh out of her thigh.
Yes, Your Honor. So the warrant shows that there's judicial involvement, right? There was probable cause to believe that Trinidad had committed a violent felony, which gave them authority to go into the home and look for him. This court in Hicks said that Bivens involved a claim grounded in a right to be free from warrantless searches and seizures, which is distinguished from one that is authorized by a warrant. Of course, there's also qualified immunity here, but we don't need to get to that because this is a new context given.
Can I ask you about the category of defendant? You were talking with Judge
Yes.
Richardson about, FBI and then marshals. Would you have us draw a distinction between the Marshal Service generally and the Fugitive Apprehension Task Forces? Or should we just consider that all as just the Marshal Service is a different category? Or are the task forces the category you're talking about?
You could do it either way, Your Honor, but our argument does rely on the task forces, and this cooperation is one of the things that makes this case different from Bivens, and that is the factor that the Second Circuit didn't have a lot of analysis.
Because
but the Sixth,
that act of Congress in 2000 is what created this federalism issue. Is that right?
So the Marshal Service operated with cooperation before that, but the act
Right.
in 2000
Right.
certainly is something that both the 10th and the 11th Circuits found to be compelling. Because the Marshal Service really does depend on that cooperation, which, as those courts have said, would be chilled. If there are no further questions, I'll reserve the remainder of my time.
All right. Mr. Maloney?
Thank you, Your Honors, and may it please the Court. I'd like to address several of the questions that the Court posed to Appellant's Counsel. First of all, as far as new categories of defendants, this Court pretty conclusively addressed this question just 22 months ago in Hicks 2, when the Court decided that extending it to the United States Park Police in the Fourth Amendment context was not a, quote, new context for Bivens purposes. And this, essentially, what the appellants are asking the Court to do is revisit and change that analysis. And of course, in Fields, the Court recognized that it could also be the Bureau of Prisons. We don't think we have to rely on Fields here, because we think Hicks is very analogous. And what the Court said in
And that was a traffic stop?
that
Is
was a
right?
traffic stop, correct. And that was a Fourth Amendment seizure in Hicks, similar to Fourth Amendment here. What's slightly different is we have excessive force, but excessive force has long been, Fourth Amendment excessive force claims as part of a seizure have long been a part of the analysis of Bivens claims and have long been recognized as that. I want to talk a little bit about, and the only, as far as new agencies or expansion, the only time the Supreme Court has recognized it is in the correctional context, when the Supreme Court decided, probably appropriately, not to extend it to private correctional corporations. There has not been a situation where the Supreme Court has said, well, just because in Bivens it was this agency, it can't be another agency.
You know, Egbert is kind of hard to parse that way, isn't it? It's, the Court says, we've typically kind of asked two questions, but then in Egbert they say, it really all boils down to one question, even though we say new context and factors counseling hesitation. It's really just one question. Is there any reason to think Congress might be better equipped to create a damages remedy? And then they turn around and say, in most every case, there is a rational reason to think that Congress should decide whether to provide a damages remedy. So that doesn't seem to leave us much room at all, does it?
Well, no, but that has to be read in the context of the decision in 2017 that there's still good law in Albany. And in that particular case, the Supreme Court outlined and Ziegler rather, the Supreme Court outlined 7 different factors that we have to look at. And those 7 different factors included the rank of the officers involved, the constitutional rights at issue, the generality or specificity of the official action, the extent of judicial guidance, the problem or emergency to be confronted, the statutory or legal mandate under which the officer was involved, the disruption of the judiciary and of the function of the other branches, and the presence of other special factors that Bivens did not consider. That's good law in Ziegler. And we have cited on pages 19 and 20 of our brief a long list of cases where federal courts, including the Sixth Circuit, as well as district courts, have recognized that the cases, that Fourth Amendment cases involving United States Marshals are not a new context. And the trial court very carefully in this case applied all of the Ziegler factors. These were low-line officers. The constitutional rights at issue, the Fourth Amendment seizures, were well in hand and well described. The specificity of the official action was quite specific. As far as the extent of judicial guidance, these are basically settled questions of law. The legal mandate in which they were operating, we've talked a little bit about, and I'd like to address the task force issue. And there's no risk of disruption of the judiciary into the function of the other branches, as there might have been in Egbert because of issues involving border issues, or there might have been in Hernandez because of border issues or other cases, or Ziegler, where there was a terrorism issue. We have none of
Why don't we think about this sort of cooperative federalism, right? The federal government assisting the state in the enforcement of its laws to be more analogous to these sort of immigration cases where we're dealing with the relationship between different sovereigns that the court says, like, precluded recognizing a Bivens remedy. Why wouldn't we think about the sort of relationship between the federal government and the states in an analogous way? I understand that they are not the same, but they're analogous in that we're dealing with the relation between different sovereigns.
Well, because the public policy issue here, what the government has cited in these other cases, a quote, chilling effect that was cited in the 10th Circuit. But here we have the opposite effect, because every other member of the task force that was not federal had liability here, had Bivens-like liability. The local government officers, the Prince George's County Sheriffs, were subject to the Maryland Local Government Tort Claims Act, as well as 1983 liability, and they would have had liability had they been the actors in this case. The other state members...
That might or might not be true. We can debate that, but go back to my question, which is like, we're not addressing those folks right now. What we're asking is, like, is it sort of new, and is there reason to think that, like, Congress might be better to try to figure out how we balance the interests between the federal and the state sovereigns and the interaction that they have? The Supreme Court seems to suggest in the line of cases that you described that when we talk about the relationship between different countries, that strongly suggests to us that that ought to be an issue for Congress and the president, not courts. And my question is, why don't that same type of analysis suggest to us that that Congress and not courts ought to be the ones that, like, try to figure out this sort of cooperative federalism relationship?
There is nothing in the 2000 congressional enactment that deals in any way with the suggestion that Congress intended to limit Bivens liability or to do anything in the task force concept. And as counsel just admitted to you, we've had task force in this country long before Congress enacted the 2000 statute. And in all of those cases, we had Bivens liability as well as concurrent liability of state and local officers. And there'd be no policy reason to do this. These officers are effectuating.
So in your view, the treating this sort of like relationship, this cooperative federalism, is literally the same thing as a federal agent enforcing a federal law?
No, actually, this is a case where, this is a case where...
They're different, right?
They're different.
Help me understand why they're different.
This is a state law case involving a state court warrant that was issued in responsibility of a state official, the sheriff, to do in response to, and is governed under color of state law. There are no federal issues here. This isn't like
Well, there's a federal issue because the federal government has agreed to assist states in arresting violent criminals, right? So Congress has given the marshals the authority, indeed one might say the obligation, to assist the state sovereigns with, like, rounding up and arresting violent criminals, right? So yes, you're right. It's all a state issue, except for the fact that the marshals have been instructed to help their sovereign counterparts in rounding up violent criminals, right? So otherwise, like, you're right, it's a whole state issue. The only thing that comes into play here is that this is federal government in cooperative federalism assisting the state government.
Well, what that question would suggest then is if this had applied outside the task force context, that there would be liability for the U.S. Marshal, but when the U.S. Marshal comes in and helps the locals for that very same conduct, there would be no liability whatsoever.
Well, I think there might well be, we decide cases based on what's before us, but there might well be a different scenario. The U.S. Marshals doesn't enforce very many federal laws, but if there was a statutory authority for the U.S. Marshals to investigate and arrest for violations of federal law, the only one that I can really think of are the registration cases. Maybe that's a different scenario, right? So if they were performing a different function, perhaps that's a different scenario. But what we have is the situation we have, which is like a pure cooperative federalism
I would
context.
suggest to you that it would be very troublesome if a United States Marshal engaging in excessive force were to be held liable if he were not doing it in the task force, but he would be held not liable if he were assisting his fellow officers from the local governments. And in fact, the dichotomy, the unusual thing that it creates here, is that if that analysis were applied, you would be creating a zone of immunity on the task force where every member of the task force who's state and local, has liability for 1983 liability as well as under the State and Local Tort Claims Act, but their federal counterparts on the task force would have immunity, but they would only, or not be liable, and they would only not be liable on those occasions when they were in the task force. But if they were assisting on other joint raids and they were not doing it as part of an established task force, they would not be liable. That's a very slippery slope, and one that I don't think the court would go down on, and one that's not supported by this record, by the way. There's nothing in this record that would suggest that what happened here with this task force would, quote unquote, create a new concept. This was a garden variety arrest warrant, a state arrest warrant for a state crime issued by a state officer here.
The challenge, and I'll just give you one more chance to answer it, and then you can move on and talk about other things, right? When you say that, you sort of make the point that it's different, right? It's a state crime, it's a state warrant, it's a state issue, and the federal government is involved only by virtue of congressional obligation and authority to provide assistance to the state process, right? They're not enforcing federal laws, right? Instead, what they're doing is they're assisting their state counterparts in rounding up violent criminals, right? That's what they're doing. The fact that it is a different sovereign's laws and the federal government is assisting them, like, feels different than the scenario where you have a DEA agent who's enforcing federal DEA laws. That's what I'm trying to get at. Do you think that those are the same, or do you see that there's a distinction between the two?
I don't think I think they're essentially the same, whether this U.S. Marshal is doing it as part of a task force or whether he's doing it just voluntarily. Not all these activities, these joint activities, happen with task force. Some of them, they just go out together without being part of a task force. And prior to 2001, they weren't part of the legislation at all. And there is, Carlson said, that you have to look at some specific intent by Congress by creating a remedy or creating some other authorization where Congress intended to take them outside of the ambit of Bivens. There is nothing, zero, in that 2000.
Your view is that absent express congressional indication that they are not subject to Bivens, that we default to them being subject to Bivens?
No, but what Carlson has said is that if you're going to rely on some federal appropriate remedy language here, that there's some other remedy available, there must be some indication that Congress intended that as an appropriate substitute. And there's nothing like that here.
Since Carlson, hasn't the Supreme Court cut back on the idea that we evaluate how sufficient the alternative remedies are?
Well, since Carlson, we've had really Ziegler, and we've had Egbert, and there have been suggestions, there's been some narrowing of the scope and some suggestions there may be more in the future, okay?
What the court has said in those cases, it's about deterrence, not about the court looking at how sufficient these alternative schemes that Congress created are, right? That it's less about the court evaluating Congress's judgment and more of a default that there is no action unless we see something to the contrary.
Well, I think the most specific thing that the court said was in 2017 in Ziegler, where we were given that 6 or 7 part test as to what you would analyze, the test that I just recited. And that's the test that the trial court applied here. And the trial court applied it very carefully. And in all 7 categories, the trial court found specifically that this met the Bivens test, that this was not a new context. And I think it's important, based on principles of stare decisis, that we rely on not where Bivens might go in the future, but what the courts have said now, what the Supreme Court actually said in Ziegler, what the Supreme Court actually said in Ziegler, and what this court actually said both in Field and in Hicks 1. If you rely upon those cases as stare decisis, and those are the governing
And we have
cases.
Dyer too, right? Do we have a
Yes.
case from our court where we found a new context because they were a different federal law enforcement officer operating under a different mandate? That was TSA, I think.
Yes, but that was an entirely different issue involving national security and TSA. We don't have any national security implications here or any TSA issues. And I think the point was made in one of the opinions in Egbert that there are 82 different federal agencies, and the original Bivens agency, the Federal Bureau of Narcotics, doesn't even exist anymore, okay? So if you take that, you'd never look at another federal agency. But this court has said 22 months ago explicitly that the United States Park Service, by expanding it by adding the United States Park Service, it was not a new context. There is no principled way to not apply
Well,
that.
Judge Richardson has pointed out that the United States Marshals are not, they're not like other law enforcement officers just enforcing, they're not federal police officers enforcing federal laws in the same way that the park police might be.
Well, no, actually, it depends on what function they're performing. And when they're performing a garden variety state arrest case, and this was this was an assault case, a domestic violence case, an assault case, and when they are performing that well-established, what the courts have called, quote, run-of-the-mill Fourth Amendment excessive force cases, they should be viewed with the standard classic Fourth Amendment analysis as far as those cases in Bivens. And the case law for Fourth Amendment in Bivens is overwhelmingly held that it is not a new context when a federal agency, not involved in national security, not involved in immigration or terrorism, but doing a garden variety stop that involves Fourth Amendment excessive force, is not an expansion.
So we have to disagree with the other circuits that
Well, I think you'd
address
have to
the
disagree
Marshal
with your
Service.
own, this court's own holding.
Do you agree we'd have to disagree with the other circuits at the 11th and the 10th and the 6th and the 2nd?
Well, not with the 6th, because the 6th decided Jacobs.
Do you agree we'd have to disagree with the 11th and the 10th and the 2nd?
Well, certainly the 2nd, they've issued a recent decision in Izzy that multiple views on that. You'd have to disagree with the majority opinion in that. You would have to agree with the 10th, but the 6th Circuit in Jacobs
And the 11th?
and the 11th, but the 6th Circuit said in Jacobs, which is still good law despite its subsequent holdings, the 6th Circuit said that excessive force for United States Marshals in Jacobs is not a new context and found it was there.
Yeah, they didn't really address the new category of defendant, maybe because that hadn't been made explicit by the Supreme Court yet. It didn't appear that the parties disputed that prong of it.
Yeah, but I think you'd have to disagree. You'd have to disagree with your own precedent. You'd have to disagree with this court's holding in Hicks 2, which was just 22 months ago, and you'd have to disagree with the majority opinion in Field, which was even more recently.
Which are different contexts.
I don't think that Hicks 2 is that much different a context. It's a federal agency. They're performing a garden variety stop. It's a Fourth Amendment seizure case. The only difference here is that there was an excessive force allegation. The warrant issue, and just let me address that briefly, as the trial court found, the warrant issue, quote, the existence of a warrant is largely incidental. The warrant really has nothing to do, as I think Judge Gregory's questions pointed out, with what happened here. We're not contesting that there was a valid warrant here or that the warrant has any basis in the analysis.
Are you contesting that the warrant is what permitted them to break the door down and send the dog in?
No, we're not at all. The warrant is just a non-issue here. The issue here is the excessive force. Where this court said in Anna Peretti about the warrant issue, it creates a new context where a warrant's being contested and you're challenging the, quote, information gathering and case building activities that represent a different part of the apprehension and detention. And that's not what we're doing here at all. And most of the circuits that have addressed this warrant issue have found that in excessive force cases, the presence or absence of a warrant is irrelevant for Bivens purposes. In the 10th Circuit, in Logsdon, where the court went in another direction from us, they did hold, though, and this is a 2024 case, that, quote, "the existence of a warrant has no legal significance in an excessive force case." And in 2023, the Seventh Circuit in Snowden said, quote, "warrant or no warrant, the claims here in Bivens stem from run-of-the-mill allegations of excessive force during a warrant." That was a case where a DEA agent, it's been expanded to DEA, had punched someone while they were serving a warrant in a hotel lobby here. So the warrant here is not an issue here whatsoever. This is the same kind of case that you saw in Bivens. This is effectively a federal agent here serving or making an arrest. It's a Fourth Amendment seizure. It's not disputed. It's excessive force. This is classic Bivens. The trial court got it right. This is not a new context. There's no need for any additional analysis. And Congress has not created an alternative remedy here. The only, quote, remedy, the only language that you could rely on from Congress is that, quote, "the agency has the authority to manage and discipline its employees." One sentence. That's not enough to create an alternative remedy, nor is the Federal Tort Claims Act. And I thank the court.
Thank you so much, Mr. Maloney. Ms. Kersvaugh, you have some time left.
Thank you, Your Honor. I just have 3 quick points. I want to clarify that the state and local officers that are part of these task forces, when they're deputized to part of the federal task force, they are federal officers. They have their federal hats on. 1983 does not apply. That's the other thing is, my friend at the bar talked about the long history of the Marshals Service and the fact that Congress has repeatedly legislated in this area. The Supreme Court has told us is another reason to hesitate, because Congress hasn't created an individual damages remedy even after repeatedly legislating in this area. And the Sixth Circuit's decision in Jacobs was a pre-Egbert case. After Egbert, the Sixth Circuit gave us Kane, which just found that the marshals were a different context. If there are no further questions, I would ask the court to reverse.
All right, thank you so much for your arguments. Thank you both. We'll ask the deputy to adjourn the court, sine die, and then come down and greet counsel.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.